అందరికీ శుభోదయం. వెల్కమ్ టు లీగల్ మ్యాటర్స్ బై సాయి బాబు సుంకర. గుడ్ మార్నింగ్ టు ఆల్ ఆఫ్ యూ. పంజాబ్ అండ్ హర్యానా హైకోర్ట్ Justice Just Gurpreet Singh Puri, he lamented that this is a classic case of Kalyug. So, Kurtayugamu, Dwaparayugamu, Tretayugamu, presently we are in Kalyugam. Kalyugamలో కూడా 4వ పాదంలో ఉన్నాం. Why he said that classic case of Kalyug? Because the son challenged the maintenance of 5,000 rupees per month to the mother. In simple terms, the family court Sangrur of Punjab, they have directed the son, who is the appellant in this case, to pay monthly maintenance of 5,000 to the mother. And he came to the High Court challenging the same. Is it not shameful? Is it not example of Kalyug? After all, can't he pay 5,000 rupees, 5,000 bucks to the mother every month? Did the court ask him to pay 50,000? No, only 5,000. ఏమిటిది ఎక్కడున్నాం మనం? Of course, the case law name is not mentioned. XXX versus XXX they have written. So, the High Court observed that it is a very classic case which has shaken the conscience of the court. వాళ్ళే ఇబ్బంది పడుతున్నారు, వాళ్ళే బాధపడుతున్నారు. ఏమిటి మనం? రైట్. సో దే హ్యావ్ ఇంపోజ్డ్ ద ఆనరబుల్ High Court Judge Justice Just Gurpreet Singh Puri imposed costs of 50,000 on the petitioner for coming to the appeal stage. మరి ఎందుకు వెళ్ళాడు? సో సహజంగా కేసు వినగానే మీకేమనిపిస్తుంది? ఆఫ్టర్ ఆల్ 5,000 కదా, ఏమిటిది, ఎందుకు అప్పీల్కి రావాలి? ఏదో భార్య మీద అంటే అయ్యా నాకేం లేదనుకోవచ్చు, తల్లికి ఇవ్వడానికి ఏ రోగం అనుకుంటే ఒకసారి ఇఫ్ యూ గో టు ద బ్రీఫ్ ఫ్యాక్ట్స్ ద కేస్ యూ విల్ బి ఏబుల్ టు అప్రిషియేట్ ద కేస్ వెరీ ప్రాపర్లీ. రైట్. ద ప్రిన్సిపల్ జడ్జ్ ఫ్యామిలీ కోర్ట్ సంగ్రూర్, he ordered on the petition filed by the mother under section 125 CRPC to pay monthly maintenance of 5,000. Actually, the mother is aged about 77 years. Yes, she is aged about 77 years. Father died in the year 1992. That means now she is a widow. And after the death of the father died in 1992. After the death of the father in the 1993, the son, that is the petitioner or appellant, he has come into an agreement with the mother. A settlement deed was written whereby he got 50 bighas of land, and of course he paid 1 lakh rupees as present, future and past maintenance to the mother. Now she started staying with her married daughter. So normally mothers will have affection towards the daughter. They can adjust with the daughter's house. They can't. So the allegation is that the son and daughter-in-law, they have not treated her properly or neglected to maintain this particular woman. Right. After going to the daughter's house also, she is not happy. Anyway, she has approached the family court Sangrur for monthly maintenance. Having gone through the documents, having heard both sides, this defense has been put up before the family court also, that he has paid 1 lakh as present, future and past maintenance. The honorable court, family court judge asked this man to pay 5,000 rupees monthly towards maintenance to the mother. Challenging this, he has come to the High Court because already he has given Just like the permanent alimony, he has given the permanent maintenance. So, family court order is erroneous and it has to be set aside. Then High Court bombarded him, saying that it is unfortunate to note that the son challenged this maintenance of order. Suppose after the death of the husband, out of 50 bighas, she might have got 25 bighas of land as per the Succession Act and should have got more money. Right? But now she is in a stage where she cannot maintain herself. Is it not the duty of the child, particularly the son, to look after her? Can't he maintain her? Simply saying that he has given 1 lakh rupees and washing of his hands, is it the necessity? No. You have to pay the maintenance. That too, actually, the family court actually very liberally granted that 5,000 rupees. Go and pay within 3 months. You have to give the check. Otherwise, you have to go to jail. That is the order of the High Court. Very good judgment. We appreciate it. Read it and enrich your legal knowledge. Thank you.